Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Let us start. In a significant move, the Supreme Court on Monday had permitted a 26-week pregnant married woman to proceed with medical termination of pregnancy upon noting that she was suffering from postpartum depression and was not in a position to raise a third child emotionally, financially, and mentally. After the court ordered for medical termination of pregnancy, the Union of India sought recall of the Supreme Court order by orally mentioning the same before the CJI yesterday. This was upon apprehension raised by the doctors at AIIMS that the fetus would have a viable chance of being born. Then, Supreme Court asked AIIMS to defer the termination of pregnancy and called for a special bench sitting. Accordingly, the bench of Justices Hima Kohli and B.V. Nagratna today heard the matter. Justice Nagratna said that she was disturbed and concerned by the action of the Union approaching the Chief Justice for interference of an order passed by another bench without filing an application for the same. Justice Nagratna expressed her concern that if such a precedent was set, there would be a breakdown of system of the court. While hearing the matter, the court was informed about the recent report from AIIMS in which the medical board has said that the fetus has a viable chance of being born. But the petitioner today filed an affidavit saying that she was not interested in carrying the pregnancy to term and giving the child for adoption. The bench disagreed on allowing the abortion. While Justice Hima Kohli was not inclined to permit the termination of pregnancy, Justice Nagratna observed that the mother's opinion was of relevance. In view of the disagreement, the matter has been referred to a larger bench. In another update, the Supreme Court bench comprising Justice Aniruddha Bose and Justice Bela M. Trivedi was hearing a plea for divorce by a husband aged about 89 years from his wife aged about 82 years. The wife had expressed her desire to continue in the marriage, and thus the court refused to grant divorce. The respondent wife had expressed her willingness to take care of her husband and informed the court that she did not wish to die with the label of being a divorced woman. The court said that allowing divorce in such a situation would cause injustice to the wife and hence refused to grant it. The court said that it could exercise its discretion under Article 142 of the Constitution for dissolving a marriage on the grounds of irretrievable breakdown of marriage even when one of the spouses opposes the dissolution. However, such discretion must be exercised with great care and caution. The court also clarified that since the institution of marriage is considered to be a pious and spiritual union in Indian society, a straitjacket formula for the grant of relief of divorce under its inherent powers on the ground of irretrievable breakdown of marriage may not be desirable. In the next update, the Allahabad High Court has dismissed a PIL plea seeking recognition of Mathura's Shahi Idgah Mosque site as Krishna Janmabhoomi. This PIL plea, moved by Advocate Mahek Maheshwari in 2020, primarily contended that various historical texts have recorded that the site in question was in fact Krishna Janmabhoomi. The petitioner had also disputed the legality of a compromise between the Society Shri Krishna Janmsthan Seva Sangh with the Committee of Management of Trust Masjid Idgah, conceding a considerable portion of property belonging to the deity to the mosque committee. The plea also urged the court to strike down certain provisions of Places of Worship Act as unconstitutional. These provisions deny remedy to the aggrieved person for any pending suit in which the cause of action had arisen prior to 15th August 1947. Therefore, the PIL plea prayed that temple's land should be handed over to the Hindus and a proper trust for Krishna Janmabhoomi Janmsthan be formed for building a temple on the said land. But the bench of Chief Justice Pratinkar Divakar and Justice Ashutosh Srivastav, which had reserved its verdict in the matter last month, today dismissed the petition. In related news, the Supreme Court is presently hearing an SLP filed by the Mosque Committee challenging a May order of Allahabad High Court by which it transferred to itself clutch of suits over Krishna Janmabhoomi Shahi Idgah Mosque dispute. The Supreme Court today refused to restrain a trial court from passing an order of conviction against Samajwadi Party leader Abdullah Azam Khan in a forgery case. He is the son of senior Samajwadi Party leader Azam Khan. He approached the Supreme Court against an order of Allahabad High Court passed in April this year, refusing to stay his conviction in a 15-year-old case that led to his disqualification from the Uttar Pradesh Legislative Assembly. In February this year, he was disqualified after being convicted and sentenced to 2 years in prison. The case dates back to 2008 when he, along with his father, was booked for staging a dharna on a state highway after they were stopped by police for checking in wake of attack on a CRPF camp. Khan's plea for a stay on his conviction was rejected by a local court in Moradabad and also by the High Court. So he approached the Apex Court. He has pleaded juvenility in this case, arguing that he was merely accompanying his father. In support of this, he referred to a November 2022 judgment, according to which, at the time of the offence, Khan was 15 years of age. On the last occasion, to resolve the controversy relating to his age, the court had directed Rampur District Judge to submit a report on the correct date of birth. Today, a bench of Justices M.M. Sundaresh and Prashant Kumar Mishra said that the court could not interfere with the jurisdiction of the trial court, but also assured that the controversy relating to Khan's age would be resolved promptly after the district judge's report is filed. Death penalty for mentally challenged individual is a deeply contentious issue, raising questions about justice, humanity, and the treatment of vulnerable individuals within the legal system. It involves ethical, legal, and medical considerations. Protection under Indian law to persons with mental illness or intellectual and developmental disabilities against the death penalty is conditional and limited. In an update regarding this, the World Psychiatric Association, in the General Assembly of its 23rd World Congress in Vienna, has approved a position statement. The statement recommends that death penalty should not be imposed on any person with mental illness or intellectual and developmental disabilities, and no such person should be executed. Established in 1950, the World Psychiatric Association is a global organization representing 145 psychiatric societies across 121 countries. It is for the first time that a professional organization in the field of psychiatry has adopted a statement calling for prohibition on the imposition of the death penalty on persons with mental illness. This is the first position statement which echoes the position taken in international law by the United Nations General Assembly and Economic and Social Council. While the constitutionality of the death penalty per se remains controversial, the statement acknowledges the disproportionate impact of death penalty on persons with mental or developmental and intellectual disabilities. To read in detail about this, you can visit our website at livelaw.in. In another update, the Sikkim High Court has dismissed a writ petition filed by Shri Guru Singh Sabha, a Sikh body seeking restoration of Guru Granth Sahib and other religious articles in a Gurudwara which were removed from the Gurudwara in 2017 and have been at the center of a heated legal battle. The petitioner contended that the Forest Department's inspection in 1997 led to concerns about environmental impact, and in response, a committee was formed recommending removal of the Gurudwara. Subsequently, the army agreed to hand over the structure for multi-faith worship, resolving this in the year 2000. However, in 2017, Gurudwara's articles were allegedly desecrated, causing a violation of religious rights under the Constitution. Contesting the plea, the respondents admitted to dismantling the structure, but they claimed that the articles were moved with the intention of relocation. The state also pointed out that the petitioner lacks standing and that the case involves disputed facts and religious history. The court reiterated that the state has the right to regulate and restrict religious activities if they conflict with public order, health, or morality as per constitutional provisions. Pointing out the intricate nature of the case and the necessity for a meticulous examination of facts, Justice Meenakshi Madan Rai concluded that this case was not suitable for resolution through a writ petition under Article 226 and deemed it essential for a civil court to delve into the multifaceted aspects of the dispute. The Bombay High Court today pulled up the Maharashtra government for its inaction over the dismal condition of toilets for girls in government-aided schools. The court rebuked the state for having to involve district judges to ensure proper facilities in schools, despite this being a function of the state government. Petitioner Nikita Gore's PIL seeks for sanitary napkins to be recognized as an essential commodity free of taxes and implementation of the Menstrual Hygiene Management National Guidelines of 2015. In July, the court had directed district legal services authorities to conduct surprise visits to government-aided schools and submit a report to the court. During the hearing today, Advocate Abhinav Chandrachud pointed out that either water is not available or the toilets are in poor condition, that urinals in some places were in open air conditions and could not be used during monsoon. Additional government pleader Bhupesh Samant pointed out a suo motu PIL initiated by Aurangabad bench in 2018 regarding conditions of schools in the state. The bench in July this year had directed formation of a committee for each district to inspect all schools. The committees were headed by the principal district judge of each district and were functional in each district of the state. But the bench of Chief Justice Devendra Upadhyay and Justice RFS Doctor voiced strong dissatisfaction with the situation and said that involving principal district judges to inspect school toilets to ensure facilities for girl students was an undesirable step, and that basic hygiene in schools should not require such intervention. The court directed the state to file a response and posted the PIL for further consideration on 6th December. And lastly, a Delhi court has taken cognizance of the offences of rape and criminal intimidation against BJP leader and former Union Minister Shahnawaz Hussain and summoned him to appear before it on October 20th. The FIR was registered on the complaint of a woman alleging the offence of rape and criminal intimidation by Hussain. After completion of investigation, the Delhi police filed a cancellation report stating that no case at all was made out. The complainant had then filed a protest petition opposing the cancellation report. Additional Chief Metropolitan Magistrate Vaibhav Mehta of Rouse Avenue Courts allowed the protest petition and said that the woman gave consistent statements to the police, to the court and the concerned magistrate. The judge also said that victim's statement recorded before the magistrate is the most clinching piece of evidence, especially in cases of rape, as there are seldom any eyewitnesses to such heinous offences. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.